All right, welcome back to our now last set of videos for Module 2. Now, you're wondering, right, Professor, wait a minute, I thought we were all done. We talked about international law, federal law, and state law. And yes, I have introduced the main sources of law. But you may have noticed, whether we're talking about, for example, the Florida Supreme Court in the Wilkerson case, or the United States Supreme Court in the Lujan versus Defenders of Wildlife case, or even when we're talking about an international tribunal like The Hague, or the War Crimes Tribunal for the former Yugoslavia, or whatever. Have you noticed? Courts are an indispensable part of our legal system, and courts, therefore, are, in a way, another major source of law. The reason why I treat courts as a separate source of law is because we need courts to interpret the meaning of laws. Think about Wilkerson versus Florida, right? What is the meaning of an animal under Florida's animal cruelty statute? Or think of Lujan versus Defenders of Wildlife, a federal case going up to the Supreme Court of the US. When can a private party have standing to sue the federal government to make the government comply with its own laws, right? And then we can have a host of international examples as well. The point is, courts play a really important role in the legal environment because we're always going to need courts to interpret any ambiguities in law. Another example would be, of course, under the federal animal cruelty law that was just enacted in last year. What is the meaning of commerce? And how should commerce, under the Commerce Clause, be defined and interpreted? So here I want to end with just an example of this. Although we've seen a lot of examples, consider this more of a bonus. The case of Yates versus United States. And I include it because it's actually one of my favorite cases, dealing with the sort of problems of interpretation. So in this case, John Yates, he was a commercial fisherman who was operating out of the Gulf of Mexico here on the Florida side. And what happened was a federal officer in the U.S. Fish and Wildlife Department went aboard his vessel and to do sort of a spot inspection, and noticed that Captain Yates had undersized red grouper among his catch in violation of federal rules and federal regulations. So the federal agent instructed Captain Yates, hey, keep that fish to the side so we can do a further inspection when we get back to shore. What Yates did, though, he ordered his crew to actually throw all the fish overboard and sort of get rid of the evidence. The twist in this case was that Captain Yates was charged not under some federal wildlife regulations or under the Endangered Species Act or anything like that. He was actually charged under the Oxley Act of 2002. And this is actually an important case because in the business school curriculum, because Oxley of 2002 was designed to deal with financial fraud. It was the law that was in the aftermath of the Enron implosion. Enron was this huge, giant private energy company that in 2001 completely collapsed because they were engaged in a bunch of fraudulent practices, and their accountants, Arthur Andersen, at the time one of the big 5 accounting firms, was basically participating in these financial fraud schemes. Congress, in reaction, said, look, we're going to strengthen the penalties of engaging in federal financial fraud. For example, now accountants, CPAs, when you certify the financial statements of a publicly traded corporation, if those statements are false or contain falsehoods, you, the accountant, can go to jail. So just to give you an example of how Sarbanes-Oxley really changed the landscape. And so today, just a huge deal, especially if you're an accountant or work for a publicly traded company. Now, what's interesting is what the law says, and I want to quote directly from the law. It says a person may be fined or imprisoned for up to 20 years if, quote, and this is important, this is going to be the controversy in this case, if, quote, a person knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence a federal investigation. Notice, right, the Sarbanes-Oxley Act, the federal, financial fraud law, really defines records very broadly. Any record, document, or tangible object. So what happened when Captain Yates was prosecuted in court? His lawyer said, "Look, a fish is not a tangible object. I mean, it's a fish that was not contemplated when Congress enacted the law." And that's why I signed this case, because it's really a great case going to really the heart of how should a court do its job when it's telling us the meaning of words in the Constitution or in the law. Do you look at the purpose of the law, or do you look at the actual words of the law itself? How do you go about this? Look at the purpose of Sarbanes-Oxley. Is really designed, right, to give integrity and faith in our business world, right? Make financial fraud illegal and strengthen the penalties for financial fraud. It really wasn't designed to help, deal with wildlife and whether a fisherman has caught, undersized fish. But if you look at the words of the law, that's just the purpose of the law, the words of the law, the words literally taken are, can be interpreted very broadly. So next video, we'll see how the Supreme Court decided this. I want you, though, and that's why I'm pausing here, I want you to think how you would have decided this case if you were on the Supreme Court, if you were the judge, or just as a citizen. How do you think courts should resolve these type of ambiguities, these types of dilemmas when they come up in a case? All right, great. One more video, and we'll just wrap up, and we'll be all done.